Good evening. I'm here with Justin Witkin, a partner with the Aylstock law firm in Pensacola, Florida. I asked, we are working with Mr. Witkin and his firm on the mesh cases, and I wanted to ask him a few questions about what's going on because his firm is one of the national co-counsel in this litigation. Justin, good evening.
Hi, Andy.
Can you tell me a little bit about your firm?
Sure. Our firm has been involved with mesh litigation since it got going. Mesh litigation is, depending on when you fix the start date, 3 or 4 years old now. We occupy the position of what's called coordinating co-lead counsel, which means that we have been appointed by the court overseeing the entire mesh litigation nationwide to lead that litigation among all of the aspects of litigation. This is an enormous litigation, I guess, to your clients and to my clients as well. A little perspective. There are over 50,000 cases that have been filed in the Western District, the District of West Virginia alone. There are more cases that have been filed around the country. So you've got an enormous number of cases. Part of the reason for that is that this case, vaginal mesh, the litigation involves multiple products and multiple manufacturers. You've got Johnson & Johnson, you've got Barb, you've got AMS, you've got Coloplast, you've got Cook, you've got Boston Scientific, you've got Caldera. Each of these manufacturers manufacture multiple products, and many of our clients have more than one product that they've been implanted with. So you've got many cases over many manufacturers, many products.
Can you tell me in general or what the problems are with these products, and tell me specifically whether there's a difference between different types of implants?
Sure. Meshes are generally broken into 2 types: pelvic organ prolapse, or POP, and stress urinary incontinence, SUI for short. So you have the underlying problems for which these meshes are used have to do with either pelvic organ prolapse, where you've got prolapsing or dropping of the bladder, of the intestines, different organs in your body, and the mesh is used to help support those organs, make sure they stay where they ought to be. And then you've also got the underlying problem of urinary incontinence, which can be brought about by a number of different things. It's not an uncommon condition to be found either post-hysterectomy, post-childbirth. It can be brought on. It can be stress urinary incontinence, or it can be a more significant incontinence. And mesh has been used to help treat that incontinence. It's inserted underneath the urethra, helps support the muscles that help control urine flow. So the issue with mesh is this. Let me back up and give you a little bit of history of mesh and how we got to the point that we are with these 50,000 lawsuits. Back in the 60s or the 50s, it actually started in the treatment of war wounds. People would be shot and they would have these gaping wounds in their abdomens, and doctors were trying to figure out, well, how can we repair them short of stitching them up? So certain manufacturers developed these mesh products. They're basically polypropylene, oil-based products that were used to repair large wounds in the abdomen. And the manufacturer, the way these products were designed to repair large wounds in the abdomen. Well, as time went on and doctors were trying to figure out effective ways to treat some of these other problems that were occurring in the pelvic area for women, there were efforts made to adapt these abdomen repair products, these mesh repair products, to use in the pelvis. The reason that we have the litigation that we have today is that there wasn't sufficient thought put into the adaptation of those products from the abdomen into the pelvis. The pelvis is a very different environment than the abdomen, and when the manufacturers of these products suggested that they could be used in the pelvis, they hadn't given adequate thought to the design, the way that the products needed to be designed, and to the potential dangers of using the product in the pelvis. Let me explain a little bit further. In the pelvis, when you put any kind of product in your body has what's called a foreign body reaction.
Okay.
So your body naturally fights off things that are not natural to its body. It's going to attack it, as it were. And that's a natural process, that's part of the healing process. Anytime you get a cut, that happens. So when you insert something into your body, it's important that it be designed to work with the body's natural foreign body reaction process. We know that's going to happen. And these meshes that were used in the abdomen, they were basically just thick pieces of rubber that were being stuck down into the pelvis. Well, that's not a design that is well thought out for the foreign body type of reaction that's going to happen in the pelvis. There's a term that we use, it's called lightweight large pore. And the idea is that if you design a mesh so that it looks like this, so there's big spaces and there's not a lot of it, your body is able to incorporate that mesh without having an effective process that ultimately leads to the rejection of the mesh from your body. So when the original manufacturers brought the mesh into the pelvic area, they didn't change that heavyweight, small pore design. They just brought it down into the pelvis. And women's bodies reject that. And they get massive infections, and those infections lead to all sorts of problems. They lead to erosion of the mesh into other organs, out through the vagina. They lead to all sorts of terrible problems.
And I appreciate that. Does this happen in every woman, or does it depend on the particular woman?
Well, the foreign body reaction is going to happen in every person.
Okay.
Whether your body is able to ultimately deal with it, able to accept the mesh without having a problem, that's not something that we can predict or know at the outset in every case. But the foreign body reaction is going to happen in every woman. And that's the reason, that's one of our main theories of liability in the case. One of the reasons we say that the manufacturers have done something wrong here is that there are designs that can be utilized that lessen the likelihood of sustaining an injury. So it's not to say that we can guarantee that women will never have a problem, but we believe that the manufacturers have a responsibility to employ the designs that make it least likely for a woman to have a negative outcome.
Were there some products that were more dangerous than others?
There are. There's lots of different products over lots of different manufacturers. And some of the manufacturers learned over time, and they changed their design to be this lighter weight, larger pore. So some of the last products manufactured by certain manufacturers are less likely to cause injuries than others. The POP products, going back to the distinction between the POP and the SUI products, the POP products the FDA looked at all the safety data associated with the POP products and ultimately concluded that the safety data was not in favor of continued use of the products, except for in very limited circumstances. And so the FDA said to all the manufacturers, hey, you need to go out and do some studies, called 529 studies, to establish the safety of your product.
Was this a so-called FDA warning that occurred in July 2011?
It actually came out a little bit after that, but yes, yeah.
Okay.
So let me go on though and tell you a little bit more about the products and the theories of liability here, because not only do you have a design problem, but you also have a failure to warn problem.
Okay.
And it's very important that people understand all devices, all medicines have risk.
Okay.
Just because you have an injury, just because you have an adverse outcome, that doesn't mean that you have a lawsuit. A lawsuit comes from wrongdoing on behalf of the manufacturer. So I talked a little bit about why we believe they designed products the wrong way. That's one of the theories of liability. But in addition to that, they've also failed to disclose to your clients the risks associated with the products. And specifically, I'm talking about the magnitude, the scope, and the severity or the permanence of the risk. Let me talk a little bit about why we're here, because again, just because you have an injury or you suffer an adverse outcome doesn't mean that you have a legal claim, doesn't mean that we should file a lawsuit on your behalf. We have to establish a wrong on the part of the manufacturer. And we generally assert two types of wrong, two distinct types of wrong. One has to do with the design of the products, and one has to do with the failure to warn about the products. So the design of the products, I talked a little bit before about the concept of lightweight, large pore, and the fact that there are better designs available that make it less likely that a woman is going to have a negative outcome or an injury associated with the product. In addition to that, there are issues about the way that the mesh is designed, like the cords, the weaving, you get fraying, you get erosion where part of the mesh, this polypropylene substance that's in your body, actually dissolves essentially into your body. You get this fraying effect and it ends up with these sharp, jagged edges. You get shrinkage where the mesh hardens and it becomes like a razor in your body. These are all design elements that we believe that the manufacturers shouldn't have used. Lastly, I'll mention that, at least as to one manufacturer, there's actually a document that we found that refers to the material that was used to manufacture the mesh, the polypropylene product that was used to manufacture. It's called Material Safety Data Set. And it says, right on the paper, not for use in the human body.
Wow.
This is the stuff that the mesh is designed out of. It's pretty remarkable.
What manufacturer was that?
Well, I can't say right now, but suffice it to say that the ingredients that are used to make mesh aren't for use in the human body. So that tells you a lot. But let me get over to the failure to warn real quickly because I want to present a complete picture for your clients and others who are listening. In addition to a design defect, we believe that there was a failure to warn. And that failure to warn has to do with an inadequate disclosure about the risks that are associated with the mesh, about the dangers associated with the mesh, the types of problems that can happen when you're implanted with mesh, and probably most significantly, the permanence of those problems. So when your clients went in and had their mesh implanted, they were undoubtedly or probably warned about the risks of surgery. All surgery carries risks.
Sure.
But they almost certainly weren't told about the significance, the magnitude of the risks or the dangers and the negative outcomes that could happen. The dyspareunia, painful intercourse, the pelvic pain that could last and be permanent. Permanent even after a revision to remove mesh, unfortunately.
Okay. Can you tell us and our clients a little bit about what's going on with the litigation process?
Sure. So litigation, broadly speaking, is broken into two different segments. There's general liability litigation, and there's individual liability and case-specific causation litigation. General liability, we are trying to prove that the manufacturers of the products did wrong, either by designing the product wrongly or by failing to warn. And so there's a tremendous amount of effort that has gone into reviewing documents from all these different manufacturers, taking depositions, talking to key corporate people within the different manufacturers' organizations, talking to experts, and getting experts to review the documents and the information that we gather and produce reports that say that what the company did in either the design or in the warnings was inadequate or was wrong. That's a huge effort that we have spent the better part of 3 years on, traveling around the world, reviewing millions and millions of pages, spending tens of thousands of hours of attorney time working that side of the case out. That's one half of the case. In addition to that, we have to establish for each individual client that they were harmed by the mesh, that it wasn't something else in their body that's causing the problems of which they're complaining or alleging their complaints, and that the wrongful conduct of the defendant manufacturer, is what caused that product.
Okay.
Okay? So when it comes to your clients, what they see, because they don't see, your clients aren't seeing any of what I just described, all those hours and all that traveling around the world. What your clients will see is they'll see a complaint filed on their behalf.
Right.
And that complaint may be filed in one of several venues. I believe most of your clients have been filed in the MDL court, which is in West Virginia.
That is correct.
Okay? So a complaint will be filed, and the next step for your clients is something called a profile form, which is a way of asking questions, finding out more about their specific claim, a written way. Now, it's possible from there that your clients would be asked to provide a deposition, which are simply oral questions. It's unlikely that any of your clients will be asked to provide a deposition too soon because, backing up again to the fact that there are tens of thousands, 50,000 cases, as I told you, that are filed, with that many cases filed, the process by which cases move through the litigation system is a much more controlled and defined process. Cases are selected, they're put into groups. They're called bellwether trial pools. The concept of a bellwether trial is that there are far too many cases to allow them to all just be tried as they would if it was just a personal injury or car accident case.
Okay.
You can't try 50,000 cases in your or my lifetime. So the judge, the court, and the parties working together come up with a system by which representative cases are going to move forward through the litigation process and be tried to a conclusion. So cases are picked to be in a bellwether pool, and those cases, if it would be one of your clients, they would actually have depositions, they would have that oral discovery that would take place, and they would have to have a whole bunch of other workup in terms of experts looking at their records and so on and so forth.
One of the questions that I get asked all the time is this a class action? And if not, what is the difference between a class action and an MDL? Can you?
Sure. This is a mass action. A class action is a case where there is a single or maybe two plaintiffs that file a lawsuit and they represent everyone else. This is a mass action because each of your clients have an individual lawsuit that is filed. It may be the case that their cases, their individual lawsuits aren't tried, it may be only representative people's cases who are tried, but each person has an individual lawsuit. Where that really makes a difference and why there's an important distinction actually comes at the end, when and if we reach a point of settlement. In a class action, if there's a settlement, it's a settlement on behalf of everybody, and everyone who's in the class has to participate. In a mass tort, there may be a mass settlement. There may be a settlement that comes out or comes on the back of one of those bellwether trials, but each person decides individually whether they're willing to accept that outcome or whether they're willing to accept the amount of money that's offered because they have an individual lawsuit. They can choose to continue their individual lawsuit or they can participate in the settlement.
So to make everything perfectly clear, it's up to the individual client to decide whether or not they want to accept a particular settlement or not. Is that true?
That is accurate. And I think that's a good segue into, we were talking about what are the client's responsibilities, what are they going to have to do with regard to litigation. And so clients often ask me, well, what can I do to help myself, or how can I make this go faster? As to the second question, there's not a lot that clients can do to make this go faster. Litigation is a time-consuming process. You have to, we say hurry up and wait. You have to be patient, okay? You have to be patient. You have to let the process work itself through. So your attorneys are going to, you, me, together, we as your client's attorneys are going to do everything we can to move the process along as quickly as possible, and we're going to keep the clients informed. But what the clients can do, and this is critical, what the clients can do is they can get themselves medical care. The best way to help your legal case is to take care of yourself medically. What do I mean by that? I mean that if you're hurt, if you're suffering an injury, we, as your lawyers, we can't fix that. We're not doctors. You need medical care. You need to get to your doctor, and you need to talk to your doctor about what's hurting. You need to be persistent. We realize that this litigation involving vaginal mesh, it's not always the easiest thing to talk about.
Sure.
I know from talking to tens, hundreds, even thousands of clients that there are many, many women who have suffered in silence, who have had pain on intercourse, have had problems associated with the mesh, all sorts of problems, and they've just either been too embarrassed or felt like they should just have to grin and bear it. That is not good for you medically, and it's not good for your case from a litigation standpoint.
Justin, I think that's so important because I've heard the same thing. I've heard many clients talk to me about what kind of pain that they're going through, and it's not just one, it's many. So your advice, and please correct me if I'm wrong, is if they're in pain, they should go to a doctor, is that right?
Yes, you need to go to your doctor. You need to explain to your doctor what you're feeling. You need to be particular in explaining when did it start, where is it hurting, because here's the thing, Andy. There are lots of things that can cause pain in the abdomen.
Sure, of course.
And your doctor, some doctors are more informed than others as to the potential dangers associated with the mesh. And it sometimes is the case, doctors may be well-intentioned, but they may simply miss, they may not be informed about the dangers that the mesh presents. And if you come in and you just are non-specific and you say, I've got some abdominal pain, and that's all you tell your doctor, well, he may chalk it up to indigestion, he may chalk it up to you overstrained your back yesterday. It could be a lot of different things. It's important that if you have persistent pain, or that if you have pain that you know started only for the first time, or is different after you got the mesh, that you go in and that you be persistent. Doctor, I'm having this pain. Let me describe it more fully for you. Let me describe when it's happening. And, can you help me understand where it's coming from and what can I do about it? And here's the thing. The doctor's not going to have a magic wand, not going to be able to wave his or her hand and cure it. But that doesn't mean that you need to just accept that either. You work with your doctor, but you need to keep coming back. You need to keep coming back, and you need to be factual, but you need to give your doctor the information. That does two things, okay? First of all and foremost, hopefully it gets you help. I mean, what you want, what your clients want, is relief. They want relief from the pain that they're in. They want relief from the unfortunate medical condition that they're in. And the only way that's going to happen is through medical care. And the only way that the medical care is going to help them is if they're persistent and if they're accurate in reporting the information. Now, on the legal side, that's our job.
Right.
That same effort to help yourself as a client, that's what's going to help you and I, as our clients' attorneys, do a good job. Because at the end of the day, when the bellwether trials have happened, and hopefully we're at a point where we're talking about resolution, what's going to matter legally is what's documented, what's in that client's file. It's not going to be good enough at that point if Mrs. Smith or Mrs. Jones says, I've been hurt so bad, I can't sleep at night, I'm in tears every day, I have to change a pad 8 times a day. If that's the conversation I'm having with Mrs. Smith or Mrs. Jones, I'm going to have to say, Mrs. Smith, Mrs. Jones, I believe you, I feel for you, but I can't do anything with that because it's not in your file, because it's not in your doctor's records. It had to get your doctor's records because in order for that defendant manufacturer to believe it, they've got to see it in file somewhere. So the most important thing that you can do, that your clients can do to help their case, is to get into their doctor and be persistent. Now, let me add one last thing. It's important because I've seen this kind of get twisted the other way. It's important that you are persistent and that you seek medical care. It's also important that you not tell the doctor that you have a lawsuit and that you're there because you have a lawsuit.
Right.
Very important. As soon as the doctor writes in his or her records, clients file a lawsuit against the manufacturer of mesh, every word that he or she writes about symptoms that may be related to mesh after that point, it's discounted. It's seen as biased. So it's important that your clients seek medical care just as patients who don't have a lawsuit.
Right.
Just be persistent and be specific.
But it's also very important that they're honest, right? If they're not having this incredible pain, we're not telling them to do something that's in any way wrong, is that right? We're not telling them to seek medical attention for constant pain when they have no pain, is that fair?
Of course not. Listen, the injuries that many of our clients have suffered in these cases need no exaggeration.
Right.
Be honest, be accurate, be fully forthcoming, don't skimp, don't exaggerate, tell the truth.
I've gotten a number of questions too, and I think we'll end on this topic about issues like Medicare and Medicaid. People have asked me questions. Well, I'm on Medicare or I'm on disability. Will this affect it in any way? How do you address that?
Sure. Assuming that we get to a point where there's a resolution here, we'll be dealing with a host of issues around resolution. We call them post-settlement issues. Those issues include liens, Medicare and Medicaid, as I just mentioned. They include any bankruptcies. I'll talk about that for a second. And the probate issues, and the preservation of benefits. Liens, first of all. For anyone who's on Medicare or Medicaid, the government requires that the amount of money that's paid by Medicare or Medicaid to the treatment of the mesh-related injury, they require reimbursement for some or all of that money. And there's a process that the government set up by which you report and then you look to resolve the government's claim. We actually hire out what's called a lien resolution administrator to deal with Medicare and Medicaid's claims, to get those claims reduced to as small a number as possible so that the clients can keep as much money as they can. That's something that we work on, actually we're working on now, and hopefully we are in a position to handle it quickly when we get to the point of resolution. So second, I mentioned bankruptcy. It's very important if your clients have filed bankruptcy or do file bankruptcy that they tell you and that they tell their bankruptcy attorney and or the trustee. The failure to disclose a lawsuit, such as a mesh lawsuit, in a bankruptcy petition, could actually be criminal. You must disclose the fact that you've filed a lawsuit to your bankruptcy attorney. Okay? Third, probate. If you've got clients that where the person who had the mesh implanted with them has passed away, it's very important that your client tells you, because in order to resolve the lawsuit, there typically has to be an estate set up. Someone has to be given the legal authority to act on behalf of the person who's passed away. So if you wait until the end, and then for the first time you tell us so-and-so has passed away, it's just going to result in delay. It's going to be a problem. Last, you asked about the preservation of benefits, or you asked about Medicaid. People who are on needs-based benefits, so that can be Medicaid, it can be food stamps, it can be housing assistance. Oftentimes at the end of a lawsuit, if they're expecting any kind of significant recovery, they're concerned about losing those needs-based benefits, and they should be. There are things that we can do that will protect any needs-based benefits. Protecting needs-based benefits, preserving needs-based benefits is a matter of weighing how much you recover versus the benefit. So if you had a client who was going to recover $500,000, perhaps she would be willing to not have Medicaid for a while. On the other hand, if you had a client who was going to recover $10,000, it wouldn't be worth it to risk the loss of your Medicaid benefits for the rest of your life. So there's things called special needs trusts that we can set up to ensure that any of those needs-based benefits are protected. And those are all things that we've done many times, dealt with those issues many times before, and we'll deal with them in this case as well.
Justin, I know I said that was going to be my last question, but I do have one final thought question that I know is on the minds and hearts of everyone sitting here and listening to this. There's been discussion in the media about settlement negotiations on these mesh cases. Can you tell me a little bit about what's going on as a general rule?
Sure. There has been media reports. There have been media reports regarding settlement discussions, and in fact, I can tell you that there has been a settlement in principle that has been reached between one manufacturer and one group of clients. And there are ongoing discussions. As I mentioned at the outset, there are a lot of different manufacturers dealing with a lot of different products. So this is a much more complicated situation when it comes to resolution than a typical case involving one product and one manufacturer. There are a lot of moving pieces. We, together, as we represent these clients, are in active negotiations or have discussions with a number of different manufacturers. Okay? But our philosophy is we need to take as much time as is necessary to achieve justice. What is justice? Okay. Justice is a fair resolution. The settlement that's been inked, at least in principle, that may or may not be fair. We aren't going to rush out and take the first thing that's offered just because it's offered. We're going to make sure that what's offered is a fair reflection of the risks of going forward in litigation with the magnitude of the harms that our clients have suffered. And when we've reached that point, when we feel like what's being offered by the defendants is in that range of justice, then we'll present it to our clients collectively. And our clients will be informed about all the facts, all the conditions that are necessary to comply and complete, participate, and they'll have an opportunity to make a choice, an informed choice. We are busy, working hard. Settlements don't happen by themselves. All the work that we've done, the years and the tens of thousands of hours and frankly the millions of dollars that we've spent litigating these cases, they've brought us to a point where these discussions can happen. And we're hoping that the discussions yield offers that are fair, that are in that range of justice. But I'm not willing to put a timeline on it because that's artificial and that's not what we do. That's not our philosophy of litigating cases. We want to come to a fair result, not just the first result. Fair enough?
Thank you, Justin. I appreciate your time.